So the life cycle of a patent application starts with the invention. So what is the meaning of invention? It is very simple that any creation of a mind which is actually used to solve a particular problem that he has observed in the market or existing products or existing technology, and he proposes a solution to it, that is referred to as an invention. So inventions are always associated with a problem and a solution, right? So basically, whenever there is an invention, it is expected that we need to get a patent application for it, because it is always whenever it is an invention, it has a applicability to it, utility to it, and the patent applications are generally referred to as utility application, as we discussed yesterday. So they need to be filed for a patent as an eligible subject matter. So how to file a patent application? The best way to file a patent application is to write your invention in a document. Now this document is a simple Word document, wherein you try to write all the details about your invention in terms of what is your invention, how it works, what are the problems that you realize in the existing products, existing technology, and how you are trying to solve such problems, the solution associated with it, and the advantages related to it, the possible benefits associated with it, and all these details have to be compiled in a document that may be a simple Word document, along with the illustrations if possible, which will help a person reading the document to understand the flow of the invention, and then submit that particular document at the patent office. We are going to see in these sessions that what is the patent office, what are the different hierarchy of the people working in that administrative office and stuff. But at the moment, let us restrict our discussion only to the steps or the procedure that is being followed. So the first and most important step that you are seeing here is filing of application with complete or provisional. So the most important difference between complete and provisional application is that complete application is an application wherein you submit all the details about your invention, including what is your invention, what problem it solves, how it is possible to implement that invention, and what all things are required, components are required to implement that invention. In contrast to this, provisional application is an application wherein you have just realized that there is a problem that is existing in the market. You know what are the possible solutions to it, or what is the proposed solution to it, but you are not knowing at the moment how to implement such solutions, or what all things are required, technical support is required to implement such things. So this is called as temporary idea or temporary concept that has come to your mind, that is filed as application at the patent office, and it is referred to as a provisional application. So there are two types of applications that we just discussed. One is a complete application, one is a provisional application. Either of these things has to be filed at the patent office, Indian Patent Office. It's also a intellectual property right office, and they will issue an application number and a date to you. So this date is a date on which you have first time filed this application at the patent office, and the application number that is also referred to as patent application number. And this application number is just a kind of an ID identifier to your application. So whenever down the line after this date, whenever you visit the government office site for finding patent application, or you visit any patent office, you just tell this number to them and they will be able to fetch all the details about your invention, or even you can see it on the internet. The only point here what needs to be understood is that after filing a provisional application, government gives you 12 months of time to submit all the details in terms of the implementation part of it to the patent office. If you fail to file these implementation details at the patent office, your application is not proceeded further, or it is not taken forward for the next steps of the life cycle. This is very important to understand. We are going to go into details of each and every aspect of this in the next couple of sessions, but at the moment let us restrict it to only the steps involved. The second and most important step is that only when the complete application is filed in the first step, the patent application which we have filed at the patent office, it will be published on the government side automatically after 18 months from the date of filing. These dates are very important. After 18 months, this application gets published. Now, this 18 months time period is the time period given by the government for free publication. That means it will automatically be published. But many a times it happens that the people are in rush of getting the application published so that they can contact the investors, funding partners, business partners, and they want to explore the possible opportunities of business in foreign countries as well. So government also gives you a provision by which you can publish your application within 1 month from the date of filing of a complete application in your case. Okay, so you can even publish it with 1 month's time period after filing of the application. We are going to discuss how it is possible to do that, but not at this stage, in the later stage. So second and most important step that is involved is publication of the application, which happens after 18 months from the filing of the case. The third and most important part is request for examination. So see, it's very obvious that we are dealing with the government offices here. It's a public servant office. So unless and otherwise you pay some fees and you file a request to do something, they will not consider your application for examination or the granting or the approval of the invention. So request for examination is a mandatory part of this life cycle, wherein the applicant or the inventor who has filed the application for the patent application, he has to go and file a request for the examination of the patent application. This examination is like considering the basic requirements of the patent office, that is whether your invention is new, whether you copied it from somebody else, whether it is it is solving some required problem, or it is like any random problem, mathematical or any specific business method related problem which may not be relevant to your market or public. These all things are scrutinized in this particular after this request is filed, and only then the examination report is issued. This examination report is a kind of let us say a questionnaire, or the, let us say for example, the understanding of the examiner, wherein they will try to share all their understanding, as well as if they have any further queries about the application that is being filed, it will be depicted in this FER. This is referred to as issue of the FER. So here it is clearly written that all objections to be complied within 6 months. So after the issuance of the FER, government gives you 6 months of time to comply with the requirements as well as to provide the required information. Okay, so this is very important part. Now after the FER has been issued, there are two possible. Once we submit a reply, or we do not submit a reply. Once we submit a reply, our application will be reviewed further and along with in view of the response that we have submitted. Or if we do not submit an FER, it is very obvious that your application would be considered for abandonment. That means they will not take it further. They will not consider it for further examination. They will just keep it as it is without taking any action on that particular part. That is referred to as the abandon. That means you will not be eligible to get a legal right of your invention. Right? Now, in this scenario where you have submitted a response, and if the response is really satisfactory, the patent office grants you a patent. Right? Grants you a patent. That means the legal enforceability is actually granted at this stage. Now, if you recall the example that I gave you for the driving license, so till the date on which you have received a permanent license, all these are referred to as a temporary phase or just an application stage. Similarly, until the grant of a patent is achieved, any step before the grant of a patent is referred to as a temporary step, or it is called as it is not legally enforceable step, right? That means you cannot legally stop anybody from copying using your invention before the grant of a patent. But yes, you can in a friendly manner inform them that you have filed a patent application, and if they are found copying, there may be some legal action taken against them after the grant of a patent. You can definitely do that, right? So this is what it is. Now you may note that there are a couple of points which I didn't discuss. That is, one is the pre-grant opposition, post-grant opposition, and the appeal. So I think that may not be really mandatory for you at the moment, but in the due course, if required, I will definitely go into details of that. But at the moment, these are not usual steps of the life cycle of a patent, right? So only the points, only the steps that we discussed, these are the important steps which are mandatorily required for life cycle of a patent application. I hope this is clear to you. Moving on, this is the life cycle of a trademark application. Similar to patent, but there are some differences here. So first and most important part for a trademark application, I hope you recall what is a trademark. Trademark is a mark which represents your trade. So that may be a logo, that may be a word, that may be anything which represents your business or trade. So this particular application has to be filed at the trademark registry. In earlier slide, I was referring as a patent office. Here it is a trademark registry. This is again a government authority or a government body which is paneled under the intellectual property office. Okay, IPO that we refer to as. So this IPO has a trademark registry inside it, wherein a trademark application has to be filed. That means unless and otherwise you go to the government official and submit that this is what is my particular mark which represents my trade, how will they come to know that there is a requirement of protection for it, right? Thus, the application has to be made for a trademark as well. Once the trademark application is made, immediately there is an issuance of an official receipt. This official receipt is nothing but basically it will be having a kind of trademark application number issued on that and a date on which you have filed. Earlier it used to take 1 to 5 working days for issuance, but nowadays everything happens very promptly. So immediately at the time of filing the trademark application, you are issued with an official receipt for the same. Now, after the official receipt is issued, within a time period of around 2 to 3 months, the examination start. Now, if you recall the difference in the patent, the examination starts at the bottom. So, for example, here at request for examination is filed at the last second or third last step, and only then the examination happen. However, in contrast to this, there is no requirement of a filing for request for examination of a trademark application. This is very important to understand. This is a slight difference or a very thin line of difference between the life cycle of a trademark as well as patents. Official, office action, that means the examination report is issued by the authorities to, based on their observation about the application which is filed. Now, there are two ways again. One is to reply, to submit the response to that particular examination report wherein they have depicted their queries, or not to submit a response. So let us assume that if the response is not submitted, what will happen? Same like patents, this case also be abandoned. If the response is not submitted, your application is not taken further, it stops there itself. However, if a response is filed and if the response is satisfactory, the trademark registry accepts your mark. Now, let me put a very important point here. It says it accepts the mark. It doesn't say it grants your trademark, right? The acceptance of a trademark indicates that it is cleared from the trademark registry, but at the stage, it is also open for public inspection. What it means is like, if in a public domain, if somebody wants to file any complaint against this particular mark, for example, let us assume an example here to better understand it. Google is a well-known company in United States. Now let us assume somebody from Mumbai, let us say in example, a Pani Puri wala, he comes and name his Pani Puri stall as a Google, and he applies a trademark for Google, right, under the Pani Puri category. So the Google who sits in United States, how will they come to know that somebody has filed a Google mark which is resembling to their mark, and he is using it for Pani Puri and not for something else, right? This is the job of a trademark registry. If the application is accepted, they publish it in a public journal. This publication means that it is an invitation for any people or any interested party having interest in such marks to come and say or come and indicate that this mark should not be granted because we are already using it, or we are the prior users, or this mark already belongs to us. This is what happens in the duration of 3 months. That is, after the acceptance, the mark which is accepted is published in a journal and it is open for inspection for next 3 months, right? Within these 3 months, if somebody comes and opposes or files a kind of request that this mark should not be granted, the trademark registry sends a notice to the person who has filed a trademark application, gives an opportunity to be heard whether it has to be taken forward or whether you are actually copying it, and based on that it will be decided whether a trademark is registered or not. If a trademark is registered, that means you can start using that R symbol which we discussed yesterday. That means your mark is registered. However, if there is any opposition or objection that is filed in 3 months time, and if the person does not reply or respond to such opposition, then automatically the application gets abandoned. I hope this is clear to you. Similarly, what happens is like, if you recall, this particular trademark application has to be renewed every time. So the life of a trademark is 10 years, but it can be renewed further for next 3 times for every 10 years. This is clear to you? One most important point to understand in the trademark application and the patent application life cycle is that in patent application life cycle, the examination happens only upon making the request of the examination, whereas in trademark, the examination happens automatically. Is this clear? Perfect. Moving on, the third important life cycle that we discussed for a trademark is that the life cycle of a copyright application. I hope you recall, copyright is generally given to the work which is artistic, literary, or dramatic, or cinematographic in nature. So such applications have to be taken care, with the utmost care, rather, in other words. Why? Because it is a creation of a mind, and that can be easily modified as well as easily utilized without without knowledge of a person. So what happens is like, please ignore the cause that is mentioned at the bottom, because that is just a general exemplary cause that is mentioned. So once the application is filed, basically this application is filed in a trademark registry. You may have noted that the terminology keeps on changing, but the concept remains almost same. 80 to 90% it remains the same. For the patent, it is always an Indian Patent Office. For the trademark, it is always a trademark registry. For copyright, it is always a copyright registry. So what happens is like, Once this particular application is filed at the copyright registry, a diary number is issued. This is also difference, right? Here we are referring it to as a diary number. In the trademark, it is referred to as a trademark application number. In a patent, it is referred to as a patent application number. You understood the difference? Application number, the number remains, consistent, but the prefix changes. Diary number, trademark application number, patent application number. What happens after the issuance of a diary number is that the government actually gives a 30 days mandatory waiting period. Now what is this mandatory waiting period is that when a copyright is filed, it is always associated with a human nature, or it is always associated with a kind of creation of a mind which is artistic in nature. So what trademark registry expect is like, if a person filing a copyright application, I'm sorry, copyright registry, what I meant, sorry for that. If a copyright registry believes that, or gives the opportunity to a particular author of a copyright application filer, that they come forward and tell them what exactly or who exactly are the direct competitors for their product in the market. For example, if a Microsoft files a copyright application for an operating system, they will voluntarily have to submit and tell to the copyright registry that Apple, or for that matter Samsung or Android, is the closest competitor for them in terms of operating system. So these are the major operating system manufacturers or producers, and thus Apple automatically or Microsoft automatically knows who their competitors are. So copyright registry expects that within these 30 days, whatever copyright application has been filed, the person who files the copyright application, that is the author, voluntarily comes and tell that these are the direct competitors and we are not copying any of their product or any of their work, right? This is the 30 minutes time period for. Now this such kind of scenario is not available in the trademark or in the patents, right? These are the slight differences in the activities, but overall steps remains the same. Now let us assume that any of the competitors did not bother to file any objection. Okay, that means if Microsoft files an operating system and Microsoft tells that Apple is a competitor, and Apple does not have any problem with that, so what will happen is, like, on the left hand side you see that there is no objection taken by the competitor company. So examiners at the copyright registry examines the application. So examination is generally done just to check whether the formal requirements are being taken care of. If the formal requirements are already taken care of, that means if there is no discrepancy, that registration of a copyright is accepted. Okay, whereas if there is some discrepancy, for example the fees required for a copyright are not paid, or some less amount of fees is paid at the copyright, that is called as discrepancy. That means any mismatching, right? A discrepancy letter is sent to the applicant, that is the author, and the author has to take care of complying with the requirements. If the author complies with the requirement, the copyright gets registered, right? Now the other scenario, if an objection is filed by a competitor, on the right hand side you will see that the copyright registry, it is mandatory for them to share or to submit the copies of such objection to the party, that is the author, as well as to the other party, that there is an opportunity of hearing to be seen. Otherwise what will happen is, like, any person without any ground, they will just file an opposition, and none of the copyrights would be granted. So that's not the case what happens here in this, right? So in this scenario, an opportunity for the hearing is given by the registrar of the copyright, and then based on that it will be decided whether the application is to be accepted or not. Ultimately this is the overall life cycle of a copyright application. Now as we discussed in our yesterday's session, that the life cycle, the life of a copyright is 60 years after the death. That means it is applicable overall to the life of the author, plus after the death of that author it is applicable for next 60 years. That means even the next to kin can enjoy the rights of the copyright for next 60 years. So this is what is the overall life cycle. Points of differences. The most important point of difference, there is no requirement of filing an examination request here, whereas in patents it was required. Second point of difference, the examination or the period of 30 days, that is mandatory objection, is even before the examination of the application. In trademark there is no such mandatory time period. In patents there is no such mandatory time period. This is the thin line of differences. Just for clarity and to be on the same page, copyright application filing and the granting of the copyright is the easiest type of IPR that one can get in the India. If you'll ask me, in my experience of around 9-10 years, I haven't seen any copyright being rejected in India. So tomorrow you come up with any kind of art, if you have filed the documentations rightly, then obviously you will be eligible to get a copyright granted for, right? So this needs to be very well appreciated. Moving on, the life cycle of a design application. Now this is really very important and interesting. This design application, as we discussed yesterday, it is also referred to as a design patent. Now filing of a design application, it's a normal step as like of any other filing, that is filing of a trademark application, filing of a copyright application, or filing of a patent application. Now what happens immediately after filing is like there is a formality check that is done at the patent office. It's referred to as a design registry, and in India at the moment there is only one design registry which is at Kolkata, and every application in India is filed at this Kolkata design registry. This is clear? Perfect. So after filing of the design application, formality check is done. If it is found that there is some issues in the design application file, for example, as you must be aware, or till now you must have got acquainted to the fact that design application is only associated with the design of a product. So for example, let us assume that by mistake this design application includes some text in it. So this is a kind of discrepancy. In the formality check, it is checked that whether any such kind of discrepancy is available or not. For example, instead of paying the fees of X amount, they did not pay the fees of they did pay the fees of Y amount. So this is a formality check that are being done. Even the required requisite details of whether who is the applicant of this particular design is also checked in the formality check. If there is something missing, the design registry asks us to amend this particular design application and then refile it. Okay. What happens is like after such formality check or after the filing of a design application, the examination of the application starts, and this time period given by the design registry is 6 months from the date of filing of the application. So within next 6 months, examination report would be issued. Examination report means again it will be showing some of the requirements or compliances requirement from the design registry, and if the examiner feels that everything is in line with the requirements, they will not even issue the examination report and they will directly accept the registration of this particular design. So within 6 months time maximum, either the design would be accepted, that means the utility design the design patent would be accepted, or there may be an objection which needs to be complied with, right? I hope this is clear to you. Most important part here is that only after the acceptance of the design application, that means design is granted, only then the publication in the journal happens, right? Now this would sound similar to the trademark wherein after acceptance the registration happens, but the most important difference here is that in trademark, after acceptance in the last 4 blocks, after the acceptance there is a publication in the journal and which is open for opposition. However, in design application there is no such thing. Once the acceptance happens, it will by default be published in an official journal, and an issue certificate is issued, that is a grant certificate is issued by the registry. There is no such kind of specific opposition period mentioned in the act for this particular thing, right? This is clear. So once the certificate is issued, like we discussed yesterday, that the renewal of a design can be done after 10 years and it can be extended to maximum of 5 years. That means total life of the design application is 15 years. However, there is a possibility that even after the issuance of the design certificate, people can file an opposition for this particular design which is granted. So there is this possibility available. Okay, this is clear now? Perfect. Now moving on, most importantly, we have seen the 4 types of IPR which are actually most importantly considered for the subject matters that come to us for day-to-day life, which you may also come up with. And the most important differences that we noted in the life cycle is that first is with respect to the publication, the order of publication, rather the order of examination, or whether actually the examination is to be filed separately or not, and the time periods. So if you ask me, though we are going to go into details of each, the longest time taken for the grant of a IPR type is a patent. So it takes around 3 to 4 years of time for getting a grant of a patent application. For trademark, if you'll ask me, it will take maximum of 6 to 8 months of time to get a grant of a trademark application in India. Copyright, it's a hardly a play of around maximum 3 to 4 months. Worst case scenario, 4 months. Okay. And design, again, maximum of 6 to 8 months. So you may note the difference is that design, copyright, and trademark, they are talking about months, whereas patent they are referred to as years. So this is a substantial difference. And if you recall, I am continuously telling you this fact that patents are the most concrete and most secured type of IPR that you may get, and the enforceability is also very high as compared to these things. Enforceability, let me reiterate, it is referred to as a legal rights that are being granted to a person or the author. Now, moving on, IPR as a territorial right. Now, what is the meaning of territorial right? Right. So you may have heard it in in the news, and you may have heard it in the newspapers. You may have read it in the newspaper. You may have heard it in any video that you're watching. So let's take a very simple example. China and India. At the moment, we are referring to a kind of area, be it Doklam or any other area. This is referred to as a territory. Territory means a boundary, right? A jurisdiction which a person can claim that this belongs to him or her, right? So territory of India is the border lines on which the area of the Indian territory belongs to or stretches to. Similarly, China also has its own territory. Any other country has its own territory. Now, what is the concern of this territory in India? Right? Let us take a very simple example. The laws that we govern in India, for example, the traffic laws, do you really feel that they are applicable in US as well? Yes, there may be common laws, common grounds, but all the laws, all the sections that are being followed by the traffic, inspector in India, are the same laws being followed in United States? The straightforward answer is no, absolutely not. Thus, this indicates that the law changes as per the territory. If the territory changes, the law as well changes. Similarly, territorial rights are those rights which are applicable for a particular territory, right? Now, IPR, what it has a relation is that all the IPRs are referred to as a territorial right. What is the meaning of that? Any IPR that is filed in India, the legal rights or the legal enforceability of those rights are only applicable to the Indian jurisdiction. Is this clear? Yes, absolutely. So basically, in short, if you file a patent application and if you get a grant of a patent application in India, that means it is legally enforceable. That means you can stop anybody from copying, selling, manufacturing, using only in Indian jurisdiction. This is very important to understand. Similarly, it goes for the trademark. That means that also indicates that any person sitting in United States or Europe or Japan or China can copy your invention and still you cannot stop them, right? Now this is applicable for almost all the type of IPR that we are discussing, that is patents, trademark, copyright, and design, except copyright has a small exception. Copyright says that there is a Berne Convention according to which the copyright, if it is filed in any one country out of 178 countries, it will be by default applicable to all the other countries. You don't have to separately file in any of the other countries, right? Unlike other type of IPRs, that is design, trademark, and patents, which are required to be filed in all the countries whichever is of your interest to claim the right because it's territorial in nature. Copyright does not mandate, or it is not required to file the copyright in all the jurisdictions. It is by default applicable in all the jurisdictions of the copyright, all the jurisdictions of the globe, right? So if I'm not wrong, 178 countries which are the part of this Berne Convention, by default the this particular copyright application is applicable for in those areas. In that also indicates, in other word, if somebody is copying the work of a person who is sitting in United States in India, that person can come and file a legal case against that particular person in India as well. Similarly, any person who is copying this particular work in United States or any other country, the person in India can stop him by filing a case in United States as well based on the copyright application filed in India. Is this clear? Perfect. So all the IPRs except copyright are territorial in nature. Why to file the IPR in countries outside India? It's an obvious question. I stay in India, my product is in India, then why should I file the application in India? For example, my company is in India, I don't have any plans to register a company in anywhere outside India. Why should I file a trademark outside India? These are very obvious questions that comes in a very almost any person's mind who is interested into securing the rights of a company or a product, right? In other words, I have a design which I intend to sell. For example, I have a nano car which I intend to sell only in India, and I don't want to go and sell my product outside India. Why should I file my design outside India? These are very obvious questions. Two reasons why one should file an IPR in countries outside India. First, one, because the nature of the IPR is territorial or jurisdictional based. That means you may get a right to stop any person from using, manufacturing, selling, importing, exporting in India after you file the IPR in India. But if the same person tries to manufacture, use, sell, export, import your invention or your trademark outside India, you will have no jurisdictional right to file any legal action against him. Is this clear? That is one of the reasons. Second reason is that unless you have a legal enforceability, how are you going to claim for the damages? How are you going to recover from the damages that have been caused because of the copying of this particular product or invention or any type of IPR that we just discussed from outside India, right? So these are the two important parts which are distributed actually in three pointers here in the slide. First is a legal protection. Obviously, the legal protection is territorial in nature, and thus for getting a legal protection for your product or services or for any of the IPRs that you intend to file, obviously you need to file your patent application, trademark application, design application outside India to get a legal protection. Even though you do not plan to launch your product or sell your product in any country outside India, still it is really mandatory that in order to get a legal protection, you file your IPRs in those countries which are outside India. For legal enforceability, obviously, if you do not have a legal protection, how you can enforce your rights? Enforce, I told you, enforceability means to stop legally with to any person who is using your IPR without your permission. How to do that? So one of the things is to claim the legal enforceability rights over the particular IPR and to claim the lawful right to stop anybody from using, selling, manufacturing, branding, exporting, importing your products or IPR in respective country, right? Business opportunities. What would be the business opportunity? Just imagine if you are just an Indian local business person, how will a person sitting in Japan come to know that you have such a kind of IPR or a kind of product that is in your mind? So thus, if you file an application in any country outside India, that local crowd in that particular country would come to know that there is something which is filed as a IPR for that particular country. I hope it is clear to you. Most importantly, the business opportunities help for licensing and royalties. Now, these are a bit technical term, they're techno-legal term rather, which helps you to understand royalty means is something like if somebody wants to use your product or use your services for a fixed amount of time, for example, a couple of years, maybe 1 or 2, he may pay you certain amount and then this amount is referred to as a royalty, and then you can enjoy the fees or the royalty, and then he can use your product and under his name and sell it. It's same like giving your flat or house on a rent. The rent is referred to as royalty, whereas this house is nothing but an IPR. So any country, any person who is interested in that country to get a particular IPR of yours, use it for his own commercial benefit, you can give the rights to him. These rights are given in the form of license. In other words, in real time example, when you give a flat for rent, you always have a rent agreement in place with the tenant, right? So similarly, in this case, in patents, the patent is referred to as the owner of the patent. The person who has filed it and who has a grant of a patent is referred to as the owner of the patent or a patent applicant. In other terms, it is also referred to as assignee. Whereas the person who takes a license or a royalty, who is interested to use the patent for a particular amount of time in that particular country is referred to as a licensee, or in other words it's also referred to as temporary owner of the patent application. So this is what basically it talks about business opportunities for the IPR. Is it really worth filing IPR in countries outside India? The answer to this question also belongs in the same category. Why one should feel that it is not worth to file any IPR in any countries outside India? One of the most important reason here is like unless and otherwise you file a IPR in any country, it needs to be noted that you will not be secured legally from stopping anybody from who can exploit your products, exploit your brand, exploit your reputation in the market without even taking a permission from you, right? So this is the reason why one should file a particular IPR in countries outside India, and the worth of filing is actually dependent on the capability of the product to capture the market. Just imagine if Facebook or WhatsApp was apps only used in United States. Will such apps or would such apps be of really critical importance today? Answer is no. These app manufacturers extended beyond the territories or the boundaries, and they entered into almost all the countries, and they are just enjoying the worth which are being generated or the revenue which are being generated out of these particular apps. Same is the example of a TikTok. Though it is banned in India, there are so many people across the globe, they are still using the TikTok, and the TikTok company, which is a Chinese company, they are enjoying the rights of it. This was all made possible because they extended beyond the boundaries. And obviously, they must have filed trademark, copyright, design, and other applications for IPR for these particular products. Thus, the worth of filing of an IPR in a countries outside India is decided based on the impact of such products in the market and whether you have trust in your products or not. Yes, it is also a fact that it is not a free of cost process. There will be money involved in it because as soon as you step outside India, everything is either in euros or pounds or in USD dollars and all those different monies. And obviously, at the moment, at the current scenario, the Indian rupee is much more lesser as compared to the other currencies. So yes, the fees are involved in that, the official as well as the other fees are involved in that, but it is worth because just imagine you never know what is the potential of your idea. If you have come up with a similar type of app like TikTok or any other app, how would you know the potential unless you file it outside India, right? So thus, it is always recommended to explore the opportunities to file your application outside India. Moving on, we are just planning to see the structure of the intellectual property office, that is Indian IP offices and structure thereof. CGPDTM, it is also referred to as Controller General of Patent Design Trademark. So this is a kind of post. For example, like we have commissioner, police commissioner, then we have DGP, then IG and other stuff. Similarly, CGPDTM is a person who is normally an IAS officer allocated for this position for a couple of years, and this person is the head of offices. So what all offices come into it? All the different offices which we discussed. So for example, the acts, if you recall what we discussed during our discussion in the first session, all these offices are controlled and managed by this Controller General of Patents, Design and Trademark. He's a person. At the moment, Mr. O.P. Gupta is the CGPD TM of India. So he manages all these offices across. So he manages does not mean that he is alone working as an administrative person there. There are n number of people who are in the part of this particular office, but he is the head of the office. Same like Prime Minister Mr. Modi is the head of the India as a Prime Minister, and there are many other administrative staff below him, under him. Similarly, CGPDTM is also similar kind of designation. First and most important office which is under the CGPDTM is called as Patent Office. It's also referred to as Indian Patent Office. So let's not get confused when we interchangeably use the term IPO. IPO stands for Intellectual Property Office as well as it stands for Indian Patent Office, right? In India, there are 4 different patent offices. India is only the country across the globe wherein it has more than 2 patent offices, right? It may be based on the number of population, or it may be based on the area of the country being huge. So Kolkata, Delhi, Mumbai and Chennai are the four different offices for patent. That means a person can file patent application in either of these offices. However, there is a small limitation. These offices are distributed based on the jurisdiction or the territorial jurisdiction. For example, Kolkata, Delhi is basically a patent office which is closer to all the people in north. For example, people in Jammu Kashmir, people in Uttar Pradesh, people in nearby Chandigarh, Haryana, Punjab, and all these people can file their patent application in Delhi jurisdiction, Delhi patent office. Whereas people in west jurisdiction, for example, Madhya Pradesh, Maharashtra, Gujarat, Goa for that matter, they all can file their application in Mumbai patent office. Similarly, people in West Bengal and other jurisdictions, they can file their sorry, not in West Bengal, but people in Andhra, people in Chennai, people in any south jurisdiction can file their patent in Chennai patent office. Whereas any people who are not any jurisdiction which are not the part of these jurisdictions, that is Delhi, Mumbai and Chennai, can file their application by default in Kolkata. Second important office that is under the CGPD TM is Trademark Registry. Trademark Registry, unlike Patent Office, there are five trademark registries. The most important registry is in Mumbai, then it is in Kolkata, Delhi, Chennai and Ahmedabad. Now these are again distributed based on the jurisdiction that we just discussed, right? By the way, CGPD TM sits in Mumbai Patent Office. So wherever the CGPD TM sits, that is considered as the head office, and thus Mumbai is considered as the head office of the all the offices. Geographical Indication Registry is basically at Chennai. So there is only one registry for the geographical indication, and that too is in Chennai only. NIIPM Nagpur, basically this is a kind of it's a kind of information storage system for all the patent offices. That means all the information associated with anything that is happening across the offices, the digital information is managed and stored in Nagpur, and it is referred to as Patent Information System PIS, and it is at NIIPM Nagpur. It is NIIPM is also involved in providing trainings and various training or exercises related to patents, trademark, copyright for the examiners sitting across any offices, and they can be trained at NIPM. NIPM also helps to conduct various courses who are willing to learn for intellectual property rights in India. That may be applicable for individuals also. So if anybody of you are interested to get an hands-on knowledge about how the patent office works and how exactly the steps of searching, drafting, prosecution and everything is being handled from the perspective of the examiners, NIIPM Nagpur is the best opportunity for that, right? So this is what is the overall structure of the Indian IP offices. Unfortunately, I haven't included the copyright office here, but similar to geographical indication registry, there is only one copyright registry in India, and that is located only in Delhi. Similarly, as I told you during the discussion, the design patent, it is filed at Design Patent Registry, which is only available at Kolkata, right? So these are the different structures and offices which are actually available in India, and all these offices are dedicatedly working for the IPR, intellectual property right related activities. I don't recall if I just mentioned that this intellectual property right offices IPR is categorized under the Department of Ministry and Commerce. So basically it is a part of one of the reputed structures in India. Hierarchy of the patent offices in India. Now guys, you must have noted that we are moving forward, or a step-by-step process towards the main goal of this workshop, that is patents, right? So here we are going into a bit detail about patenting. You may have noted in the earlier slide that patent office are distributed in four jurisdictions, that is Kolkata, Delhi, Mumbai and Chennai. Now every patent office has this structure or hierarchy. First is Controller General of Patents, Design and Trademark, CGPD-TM. The second most important position, or let us say under the CGPD-TM, is Assistant Controller of Patents. Then there is Deputy Controller of Patents. Then there is Joint Controller of Patents, and then there is Senior Joint Controller of Patents. So actually, CGPD-TM is the head of the patent office, okay, and then the hierarchy actually starts from the bottom. That means Senior Joint Controller is the closest person to the Controller General. Joint Controller is the closest person to the Senior Joint Controller, Senior JC, what they refer to as. Deputy Controller is the closest person to the Joint Controller, and then Assistant Controller is the reporting person to the Deputy Controller. All these people have some people under working under them or working under their instructions. They are referred to as examiners of patents and design. Now these examiners are people who have completed their engineering, or they have completed their graduation in engineering or life science or pharmaceutical domains, right? Because patents is a technological or technical field, and all it is associated with the inventions, that means technical inventions. There has to be people who are involved with the technology, who deals with the technology, and thus examiners are those people who deal with the technology related work for them. I hope this hierarchy is clear. Let me reiterate. The patent office structure that we saw, it is distributed into 4 offices, and each of these 4 offices has this hierarchy, except the CGPD TM sits in Mumbai, and all other posts are common, but people keeps on changing in each of the offices. Jurisdictions of patent offices, like we discussed, patent office, these are all called as branch offices of the patent office, and there are 4 offices: Mumbai, Chennai, Delhi, and Kolkata. So most important point to notice, which all jurisdictions, or which all states, or which all cities or states are the part of these, or which jurisdiction, right? Mumbai Patent Office covers the state of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, and then Daman and Diu, as well as Dadra and Nagar Haveli, right? These are all states, or these are all jurisdictions which are categorized, or people from those states are allowed to file the patent application only in Mumbai Patent Office, because this office dedicatedly works for these people and these territory only. Similarly, the Patent Office branch Chennai, it covers the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, and the union territories of Pondicherry and Lakshadweeps. Right. So maximum south states are covered under the Chennai Patent Office. Similarly, the Patent Office of New Delhi, it covers the state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, UP, Uttar Pradesh, Uttarakhand, Delhi, and the Union Territories of Chandigarh. Right. So all these states, all these parts of Indian jurisdiction are covered under the New Delhi Patent Office. Similarly, the patent office in Kolkata, like I said, all the states, all the places which are not covered under these branch offices are covered under Kolkata. For example, Arunachal Pradesh, Sikkim, Manipal, and all those stuff, all those cities, all those states are covered under this Kolkata jurisdiction. So any people sitting anywhere across the Indian states or Indian country, they can file patent in any of these patent offices, but preferably in the jurisdictions which are mentioned, specific jurisdictions mentioned here. Let us move on specifically to the important parts of our invention, that is patents. Right? Now, what are patents? Patents basically are the exclusive rights which are granted by the government to the applicant of the invention for a limited period of time in lieu of disclosure of his invention. This definition is really very important. Patent, obviously we know that IPR is a field of law, and this IPR talks about the rights given by the government to a person, so that he can exercise his rights and stop any person from using, copying, selling, manufacturing without his permission. Most importantly, patent is the term which is only used when a license or a legal right is given to a person, who is also referred to as applicant in this definition, by the government. Government is basically a granting authority. No other person has a granting authority, right? For his invention, and that too for a limited period of time. If you recall, the life of patent is for 20 years, and thus after 20 years what happens? It goes to public domain for usage without or with his permission, that is the applicant's permission. Thus 20 years time is referred to as a limited period of time here. Now this limited period of time is only granted when the disclosure of the invention is made. So in other words, unless and otherwise you inform the patent office about the invention and how it works and what all problem it solves, how will patent office will come to know that something is innovative or invention in his mind, the applicant's mind? Thus, this definition is pretty much concrete in itself. Let us read it again. Patent is an exclusive right. Exclusive means what? A dedicated right granted by the government to the applicant for an invention for a limited period of time in lieu of or against the disclosure of his invention. Is this clear? So only when the disclosure is made, only then the patent office will actually review. So if you recall the life cycle of a patent that we just discussed, the first, second, and third step are most important here. So unless and otherwise there is an invention, unless and otherwise it is drafted in a documentation format, unless and otherwise it is filed at the patent office, how will the patent office grant you a patent? Right? This patent is a term, like I said, it is to be used only when the patent is granted. Until and unless patent is not granted, that means it is in examination stage or it is in publication stage, it is always referred to as a patent application, right? In other words, patent is the term referred to once the patent is granted and legal rights of a person is started. It is very important because I'm stressing on this fact because many people nowadays, just to disguise, when a patent application is filed, they refer to as a patent, my patent, our company's patent, which is incorrect. In fact, it is legally incorrect. You are indirectly bluffing the people in the market, and thus it is not at all recommended. I have seen most of the products in the market for which a patent application is filed, but because people in India are not much aware about this field of IPR, they tend to write patented product in their products which are being sold in the market. And even though when we go back and check, they are still in the patent application stage. That means it must be either patent application filed for, or it may be in the publication stage or the examination stage, but the patent was not granted, which means if decided, any person can take a legal action or legal case for against such company for using or misguiding people in India. Now, most importantly, what is this exclusive right? We broadly discussed that exclusive rights are the rights which are given by the government. These are the legal rights. But what inside this right you get for? So, for example, let us assume. Let us compare it to the real time example. If you buy a flat, okay, you do a registration of the flat, you pay the the duties and all those things for this particular flat, and now you are the owner of the flat. What rights would you have as a owner for the flat? One most important right is that you can use it for your own benefit, right? Second is what? You can rent it if required, right? You can resell it, am I right? You can sell it again, right? Or else you can just give it on rent and enjoy the rent that is being generated out of that particular flat. You can rent it for a couple of years, you can rent it for a fixed amount of time, you can rent it for a couple of days. For example, if you convert your this house into Oyo, you can even rent it for a per day basis, right? Similarly, the exclusive rights that are given by the government to this particular patents are basically those rights which are actually allowing a person or a particular owner of a patent application to make, use, offer for sell, import his own creation, his own patent. Right? In other words, a person can stop anybody who is trying to copy the invention without his permission, without his due approval. He can stop using, or he can stop that person from using, making, offering for sale, and importing. Now, the term using is really very important here. Who will be the maker? For example, maker would be a person which we call it as manufacturer or producer. He will be considered categorized as making. So you can stop any person from who allows for making this particular thing. Using. What is the meaning of using? Using means any end user. For example, like people like you and me are the users. We are not aware whether a product which I just bought from the market, is it actually copied from any patented invention, or whether it is the creation of the seller itself, right? I would like to give a very small example here for the people who are categorized under using thing. I'm sure you must have heard that TVS is one of the two-wheeler manufacturing companies in India, major manufacturing companies. Couple of years back, they launched a vehicle called as TVS Flame 125cc, and they have a dual spark plug as a USP of that particular bike. What this the dual spark plug used to do is like it enhanced um the combustion, and it enhanced the working of the engine such that the bike used to give an average of around 120 kilometers per liter. It's a fact because I have used that vehicle, and I can assure you that the vehicle gave me around 112 kilometers average for 1 liter. Unfortunately, after a couple of years, what happened was like Bajaj also came up with its own vehicle. It was referred to as Bajaj DTSI, I believe. It was also 125cc bike. But along with that, they filed a case against this particular TVS company against that particular dual spark plug kind of product, suggesting that a person who worked on that product changed the company and broke the law by giving all the information about that particular dual spark to TVS company. So the person who was supposed to, or who enjoyed the privilege of revealing the information, he was escaped. But the company who launched the product, that means person who are people or the company who is involved in making the product, was into jeopardy, was into problem. Similarly, the people who were using the vehicle, for example, people who bought the vehicle by paying the fees, were also under problem. People like me, like, for clarity, I was one of the first users in India to buy this TVS Flame vehicle from them. Now, after 6 months, I was told that none of the parts will be manufactured for this company, this particular vehicle, because it was under the litigation, and the court gave a decision that none of both the companies, that is even TVS and even Bajaj, would manufacture or sell this particular spare parts of this vehicle. So my vehicle, I was using it, but as soon as some issue happened, there was no replacement product that was available in the market. That's thus it is very important that these exclusive rights are given not only stopping any person or a company from making, but it also helps to prevent using. For example, if Bajaj decided, they can come and stop me from using that vehicle because they have the patent and I was the user of that particular product without their permission, right? Offering for sale. Now, if let us assume that if TVS, who has taken permission from, let us assume that TVS has taken a permission from Bajaj for selling the vehicle, right? They can sell the vehicle. That means if they have taken a permission, they can sell the vehicle. But in this case, which example that I gave you for TVS Flame, they did not take a permission, and thus Bajaj stopped them from offering for sale. That means any vehicle which was sold by TVS, they were literally stopped from selling that particular product. Offer for sale means they actually are trying to make an offer for sale. They did not actually sell. But immediately in this definition, there is a next term called as selling or importing. So any person who is manufacturing, let us assume that TVS, being a smart player, they say that, chalo, we accept that we have copied your invention, but we are not manufacturing in India. We have brought all the vehicle installed and manufactured from China. But the definition of patent clearly indicates that even importing is prohibited. That means, yes, if Bajaj has not filed a patent in China, they cannot stop people in China from using, manufacturing and selling. But they have obviously filed a patent in India, and thus any vehicle which is even manufactured in any country outside India, as soon as it enters in India, that can be stopped, and that is referred to as importing. Importing means what? Asking or taking the products or services from outside countries, right? So any product which is manufactured outside India, but as soon as it enters into India, it becomes a territorial issue, Indian territory, and thus importing of the patented invention is also prohibited, right? So moving on, what is the invention? We discussed very briefly about the invention, that what exactly invention means, because patents are generally granted for inventions or innovations, right? There is a very thin line of difference between invention and innovation. I would really appreciate if all of us do a small exercise after this session to find the difference between invention and innovation, right? So one should find the difference between invention and innovation. Patents are given for innovations and, sorry, patents are given for or granted for inventions and not for innovations. Is this clear? So what is an invention? According to the law, or according to the Patents Act, inventions are nothing but it's a product or a process which actually involves an inventive step and capable of industrial application. Okay, I will explain you what exactly these particular points are. But before that, I would like to go into details of each and every of these particular terms that I mentioned on the slide. Invention means a new product or a process. If you recall our discussion yesterday, patents are generally given for products or process. Product means what? A tangible product which I can see, which I can touch, which I can feel. In other words, nowadays the definition of products have also been changed. People generally refer to it as a software product. People from IT industry, they refer to it as a software product. This product may not be tangible in nature, but they still refer to as a product because software according to them is a product, end result. Thus, any product which is new in nature, that means when we say it is new, when we say anything is new, we say anything is new, that means we haven't seen it till date, either with that person or in the market, right? Am I right? Absolutely. So any product which is new in nature, that means not available in the market or not available with that person till date, is referred to as new. So most importantly, patents or inventions are only considered when they are new in nature. New process, what does it mean? A process of manufacturing, a process of using, a process of performing, these are all mentioned as a process. In other words, process is nothing but a method, or you can even mention it as a steps. So any process which is new in nature is considered as a first parameter for getting a or considering it as an invention. Is this clear? So inventions are only associated or only considered when it is new or it is a new product or a new process. Involving an inventive step. Inventive step means what? Patent office expects only a small requirement from your side. That means according to this requirement, they say that we want to just understand what is the problem that you feel that is there in the existing market, existing literature, existing product, existing services. If you are established the problem, then there has to be a solution as well to be proposed. Only when your invention has a problem and a solution proposed to it, it actually helps to be categorized under inventive step category. Okay, so your invention should involve an inventive step inside it. Most importantly, your invention only having problem and solution may not suffice, may not be considered. This solution has to be non-obvious in nature. Now, this non-obvious terminology is a bit complex. Let me explain you what I'm referring to it here. Non-obviousness criteria means that it is in contrast to obviousness. We generally use the term obvious in our day-to-day life. It is exactly the same logic. For example, let us take an example of a pen. Okay, let us assume that till date there was no pen except a blue color pen that was available in the market. People were not aware of any other pens which are existing in the market. Only blue color pen is there. So today what happened was, like, while I was going through a market, I came across a color shop and I saw that there were blue color, there were black color, there were red color in that. And I was having a pen which was only a blue color. So what I thought of, like, instead of this blue color, can I replace the ink with the red color? The answer was yes. And I say that my invention is new because there was only blue color available. Nobody proposed a kind of any other color pen. But I come up with a new invention called as red pen. According to the patent law, this is not a criteria for getting a patent. Why? Because it would be very obvious to a person who is working in the industry of pen manufacturing or ink manufacturing to replace that blue color with the red color. This is a different issue that they haven't tried it yet. But was it possible or not? That is the question that the patent office asks, right? If the answer is yes, obviously it was possible, then you will not get an invention because your invention is not obvious in nature. Yes, in contrast to this, if your answer says that it was not at all possible because there were some technical problems and it was not at all possible to use the red color in the blue color refill, then yes, patent office may consider that yes, because of these reasons your invention is considered as non-obvious and you will get a patent granted for it, right? I hope I was able to clearly differentiate what is the meaning of obvious and non-obvious, right? So non-obvious is generally a criteria when something was in negation. That means it was established in the art that this was not possible to do. Like, for example, it is not possible to drive your two-wheeler vehicle when you use water instead of petrol. It is not possible because your engines are not made to absorb such things. This is a well-established law. But if somebody comes and try to do in contrast to this, right? If somebody comes and prove that, show that my vehicle runs on water, you will be eligible to get a patent granted. So the first criteria where we know that it is not possible to run your vehicle on water, this is considered as non-obvious criteria, right? But as soon as somebody says that I am able to do that, that means you are able to satisfy that non-obvious criteria. This was the second example that I gave. Third and most important requirement of a patent office is that your invention should not be hypothetical in nature. It should not be imaginary in nature. People should be capable of making it and using it in the industry. What it means is that any hypothetical inventions are not patent eligible. Yesterday, if you recall, I gave you an example of ether. Let me reiterate that example, okay? Ether is a medium which is available according to some great scientist, either Einstein or Newton, you need to find that. But according to him, the ether is a medium which is actually a kind of medium which allows to pass the objects through it, and it is only available between when the people travel from earth to space. So it fills the gap between the earth and space. This is referred to as ether. Now, there are so many questions on the availability of the ether as a medium in today's technical world. 99% of the people say that there is no such medium that is available in the world. But in contrast to this, I come up with a proposal that I can use the ether medium inside my vehicle and I do not have to refill the vehicle again. So it's a one time refill and you can use it lifelong. Right? Just by listening to it, it seems that my concept is hypothetical. Why? Because the law of nature says that when you are giving an input, an output is generated, and there has to be a continuous flow of input without which the output cannot be generated. Energy can neither be created nor destroyed, it is only transferred from one form to another form, which indicates that energy has to be there. There has to be an input energy. So here in this case, if you are saying that ether is used as an input energy, firstly, there is a question on the existence of ether. Secondly, if their vehicle is being driven, how will the output generated by the vehicle, it will be using or utilizing that ether as an input, then at one point of time, ether has to be finished, right? So this is in contrast to the natural laws, in contrast to the understanding of the human nature, and such examples are referred to as hypothetical. Similarly, the example that I gave, that I drive my vehicle on water instead of fuel, that is also hypothetical in nature, because at the moment till date nobody has established that. Yes, this is a different issue that, for example, let us say 50 years back when somebody dreamed of going into space or on the moon or on the Mars, that was also considered as a hypothetical. But some companies, some people proved that this was not hypothetical. We were able to go to moon, we were able to go to Mars, we were able to commute to any, outside the Earth zone, right? So these were possible, but only possible, made possible when people use satellite, people use rockets, people use spaceships to commute to those particular impossible or not possible destinations. Maybe at the moment when we say that ether is not existence and hence driving a vehicle using a ether is hypothetical, down the line after a couple of years, if some inventor come up with ether as a medium and prove that this is referred to as ether, then yes, it would be possible to say that it is not hypothetical. Similarly, if somebody proves that it is possible to drive a vehicle using water, then also it is considered as hypothetical, not hypothetical in nature. But at the moment, based on human knowledge, whatever we feel are hypothetical, obviously based on some evidence, we say that if it is hypothetical, then you will not get a patent granted for it. I hope these three criteria are clear to you. Let me quickly revise it again. Any new product or process involving an inventive step, that means there should be a problem and solution, and the solution whatever you proposed should be not obvious to a person skilled in art, right? This person skilled in art is a person who is working in that industry or domain, right? And capable of industrial application, that is applicability. So these are all the requirements for any subject matter to be called as invention. If your subject matter has any of these particular thing and all of these particular thing, only then you would be eligible to file a patent application. Moving on, you would see that I have just explained it in detail that patent can be given for what? Patent can be granted or considered to be filed for what? Patent can be filed for any invention of a useful process. Invention having a useful process can be considered or eligible to get a patent for. Any invention of a product, a patent is generally given to a product which is inventive in nature or has an invention in itself. Any new and useful improvement done in an existing product can be considered as a patent, can be considered eligible for a patent. Inventions which are novel in industrial applicability and have a industrial applicability can be considered as patent eligible subject matter. Let's take example of all these things. Invention of a useful process. Can anybody think of a useful process? Process of what? Let us take an example, okay? In let us say 15 years back, okay, the communication between one person sitting in Mumbai and communication between the person sitting in Jammu Kashmir, it was very difficult, right? It was difficult because there were a lot of issues. One most important issue was communication links establishment. Mobile phone tried to solve this particular problem. A process of using a particular product to commute. This is nothing but a process which is useful in nature. It can be considered as patent eligible. A process to commute from one place to other place by using some means, for example, aeroplane. It is a useful process, right? New and useful improvements. So for example, if I am using a mobile phone, 10 years back there was this Nokia phone and now these are all smartphones. Any improvement, purpose is same, that is phone, that is to commute, communication, but there has to be a substantial improvement in that, and any such improvement which is eligible and new and useful category, it is considered eligible for getting a patent granted. Invention of a product, what can be example, right? Have you seen the electrical razors? Earlier there was this physical activity that needs to be done. Nowadays it is a electronic or cell based or battery based razors that are available in the market. What are these examples of? These are all examples of product. Alexa, right? Alexa, what is this? Alexa is a product which makes the life of the user easier. Amazon Fire Stick, these are what? These are all examples of the product which makes the life of the user much more easier as compared to the conventional one. Inventions which are novel, having inventive step and industrial applicability, right? COVID vaccine. Any particular company who plans to come up with a vaccine of COVID or corona, they are considered as inventions because these vaccines are not only new, they have a problem solution approach. They solve some problem, they provide a solution, and obviously it was not obvious to a person skilled in art because till date there was no vaccine available for COVID, and everybody says that there was no vaccine. If any country or any research and development scientist comes up and say that there is a possibility that a COVID vaccine can be produced and I have a proof for it, obviously it is considered as non-obvious. Most importantly, it has industrial applicability because once people start using this vaccine, nobody will fall sick, nobody will be uh, death, nobody, there will be no death because of the COVID. So these are all categories of the invention, and thus patent can be filed for each of these particular country, these particular subject matter. Let me just quickly check whether we will be able to wrap it or not. Yes, I think we will be able to wrap it. So reasons for patenting invention. What are the reasons why one should file a patent application? Why one should not directly publish a research paper or just go to some government agency and say that I have a patent application, I have an invention? Why one should not directly publish it in a newspaper? Why one should not just publish it in a journal or a thesis? Most importantly, if you have done some invention, you need to have an exclusive right for it. And the exclusive right is only given when a patent application for it is filed. If you do not file a patent application at the intellectual property office, obviously there will be no rights given to you and any person can exploit your invention without your knowledge, without your permission in the market. You don't want to do that. And thus, exclusive rights are to be granted for patenting the invention. Hence, file a patent. Increase market position. Just imagine Today we are in a world where smartphones are our life. We cannot stay without a smartphone for maximum, minimum of 1 minute or so, right? At least I cannot stay without a smartphone for a minute. I feel like something is missing. 10 years back, this was not the case. 15 years back, this was not at all the case. 20 years back or 100 years back, there was no phones. People used to still stay. So how the market position is relevant here, because the products like the phone, the television, the laptops, they made the people so adapted or addicted to the technology that people expect improvement in each and every product. Today, if my phone does not have 60 minimum of 4 GB RAM and 64 GB of hard disk, or let us say storage, I will not be happy to use the phone. What is this? This is the expectation. And thus, each company today is trying to increase the market position and market value for themselves. How to do that? One way to do that is you stop your competitors from using your technology and come up with the new innovations. How to actually establish that? One way is by filing a patent. Other is directly launch a product. If you directly launch a product, it is likely that if it is really very helpful to the public and it is popular, somebody will try and copy it. How to stop them? Patent is only the key, and thus file a patent. Opportunity to license or sell the invention. Like I gave the example of a flat or a house, obviously it is expected that whenever you have some particular product, you can enjoy the monopoly, you can enjoy the rights for each of these products by either selling, by either licensing, or by utilizing it at your own benefits for your own purpose, right? So these are the few things. Positive image on your CV. Now this is generally for the people, especially from R&D profession, as well as from the academic institutions, where for the appraisals, for any XYZ reasons, they are interested just to file any of the IPR and get your grant. Right? So this actually helps you to show that you are innovative person, you are a person who thinks out of box, person who is actually having technical expertise, and people obviously try to think something different for this person. And this is very true, because just imagine every year there are lakhs and crores of engineering or any other graduates which are passing. Almost all the students study from the same book, they have the same teacher with the same qualification. How will you prove, or how will you establish that you are something different, or you are something out of the box thinker than any person nearby you or any student nearby you? One way to do that is file a patent and show that you have done something extracurricular, something extraordinary as compared to the other people who were enjoying their time by watching movie or by going out for trips. This is how people think nowadays. Not only that, even foreign universities try to give certain amount of percentage if some people are found with some extracurricular skills like this. I know many people, many universities in US and UK and Germany and Canada, wherein people actually try to focus or try to find the candidates, give the admission to the candidates who have such skills which are something different from the normal study or curricular activities, right? So just this particular point is very relevant just to show a positive image on your CV. Moving on, benefits of the patenting system. You may have noted that we have seen all those points like licensing and revenue and stuff. These are nothing but what? These are all benefits of a patenting system, right? So benefits of the patenting system is from two perspectives. One is from the perspective of the inventor, innovator, and second is from the perspective of public. From the inventor's perspective, the benefits of the patenting is that you get a particular legal right for this particular patent for limited amount of time, limited years, right? Whereas you can also promote your technology of inventing and innovating. You can even sell it to the people, you can generate a revenue for personal benefit, or you can even license it or sell it and enjoy the revenue generated out of it, right? from the perspective from the perspective of the public, one way is that one way is that once the life of a patent, that is 20 years, is over, the technology falls into public domain. That means it is freely available for public usage, right? Society becomes aware of technological development. Unless and otherwise you file a patent, unless and otherwise you disclose it to public, unless and otherwise you do not bring it out of your mind, how will people come to know that there is something technological development that are happening in a? Everybody will stay in the old age technology only. There has to be a development that is happening, and to prove that, to show that, patent has to be filed, because patent is only the eligible right for technical stuff, right? Avoid reinvention of existing technology and investment of resources for the same. Just imagine everybody keep on following the same inventions all together and nobody is doing any improvement. And what is the use of that particular technology? Technology is said technology only when it is referred to as having a capability of improvement. If any technology has no capability or no scope of improvement, it may not be referred to as technology and may not be essential for this particular benefit of public. Let's take an example. The telephones that we used to see 5 or 10 years back, they are almost on a verge of finished, or almost on a verge of finishing. I haven't seen any home without a telephone like 10 years back. But now if I see, everybody has a mobile phone, everybody has a smartphone, and thus the requirement of telephone is actually being finished, right? This is what is referred to as, if you do not reinvent, if you do not try to improve the technologies that are there, the investment or resources are finished, right? So thus patents help you to do and understand what are actually improvements that are happening in the world across the globe, and also it also helps to understand the technological development that is happening. Lays down favorable environment for competition. Obviously, when a competitor company or a competitive person finds that there is some technology that is available in the market, he will try to do something different from that. And in this doing different thing, he may end up with doing something in an improved manner. Let's take another example of how the improvement is shown. When data from one mobile phone has to be transferred to another phone, there are various technologies. One is Bluetooth, which is a conventional technology. Every phone has a Bluetooth, almost every phone has a Bluetooth. Then there is Share It, then there is Wi-Fi Direct, and then there is WhatsApp and other social networking apps, which also helps you to share the data. What is the difference between these all technologies or mechanisms? The most important difference is the speed. If you use a Bluetooth and if you want to transfer 1 MB of file, it will take around 3 or 4 minutes. In contrast to this, if you want to transfer the 1 MB data from one mobile phone to other mobile phone using Share It, it will hardly take around 1 minute, within 1 minute of time. Similarly, if you want to transfer data from one device to other device using WhatsApp, it will take only few seconds. These are what? These are nothing but all the technical advancements that have happened, that are happening across the globe. And these all technical improvements are because one technology came into market and other competitors tried to find an alternate approach or better approach to the same. Thus patenting gives you such kind of hope. Any interested person may buy the patent, wherein the patent becomes important tool of technology transfer. So indirectly it is a buy and sell kind of economics, right? The transfer of the property, ultimately it will help to grow the GDP of the country. It will help to generate the personal revenue of a person, and it will also help to to understand the importance and the price of the technologies in the market. Thus it is actually an important tool, right? Moving on, these are the essential parts for the patents. Now what are the essential parts? We discussed this. It's the same slide. We're going to go into details of the examples now. Novelty, industrial applicability, and inventive step. if your invention or if your document has these things, you will be allowed to get a patent. Patent will be granted for how many years? 20 years from the date of filing. Right? This is the most important part. On the right hand side, you see that it is written as first to file. What does it mean? It means that any person who files the application first, he will be considered as a right owner of that particular patent. Now, this is very important concept. Why? Because let us assume a scenario X and Y. X is a person who is actually working in an R&D, and something comes in his mind which is really very innovative, and it is going to change the scope of the world, change the living of people across the globe. But what happened was like X, in the flow of happiness, he kept on digging in, he kept on doing R&D, he kept on doing product manufacturing, he kept on selling the product. But what happened in the meanwhile is like why a person who was sitting next to this X realized that X has come up with something very nice innovative thing. He stole the data from X and filed the patent for it before X. Now, what is the impact of that? When down the line after a couple of years, X launched his product in the market. Immediately after that, Y, who actually filed a patent for it and the patent now is granted, he stopped X from selling his own concept, his own product. You know why it was possible? Because X did not file a patent and Y filed it. In other words, Y filed a patent before X even thought of filing a patent. Thus, across the globe, one most important part is to be understood is that patent is granted for scenarios where patent is filed first. Patent or the inventions in the mind are of no use. If they are on paper, they are of no use. If they are in textbook, they are of no use. If they are written on a wall, they are of no use. Patent has to be Inventions has to be filed for patent or applied for a patent in the form of patent application. Only then whosoever files a patent is actually eligible for first to file concept. If any person who fails to file a patent and somebody else files a patent, he will be given the priority under the first to file concept. Right? Now, 20 years of the patent is actually a patent. The legal enforceability, like I said, it actually in this 20 years, it is eligible only after the grant of a patent. But that does not mean that any person before the grant cannot stop anybody from copying it. Let us assume a scenario wherein a person copies a patented invention or patent filed invention from a person who has patent not yet granted, but it is just in a filing stage. So what this person or the owner of the patent application can do is like he can send a friendly notice to the person who is copying it, indirectly telling him that boss, please stop copying it, you are copying my invention and the like. This is just a kind of intimation given, but in a friendly manner, not in a legal manner, right? Most important term is not in a legal manner. So what happened is like ignoring the fact or ignoring the intimation, this person kept on copying it. What happened in the due course, after a couple of years, this patent got granted. Now this person whose patent got granted, he can sue this person who was copying it from the date on which he has sent intimation to this person for the damages, seeking damages, till the date on which he has got a patent granted, or in other words, he has decided to sue that person, right? So this is the power of a patent. Even though if it is patent is not granted yet, still people can stop indirectly the people from copying, using, selling, manufacturing it. And if they do not stop, then they can claim the damages from it. So technically the right of a patent starts from the date of filing of a patent application. Is this clear? 20 years from the date of filing, but the legal right starts only from the grant of a patent. First to file is a concept according to which any person whosoever files the patent first is given the priority first, and any person who is filing the patent second, he will be considered always second. Okay, is this clear? Perfect. Now moving on, though this slide is bit let us say bigger, actually this slide covers all the essentials of getting a patent granted in India. I don't think the overall slide will be covered, but I'll try to cover maximum, and remaining slides can be taken in the next session, tomorrow's session. Okay. Now we have seen that on the left hand side. Let us start with the left hand side because the flow of this particular conditions. You can also refer to these as essentials for getting a patent granted, or essential criterias or checks that the patent office performs, before the granting of a patent. First and most important part is like, if your invention is not novel, that means it is not new. Novel means what? It is referred to as uniqueness also. It is referred to as newness also. If your invention is not new, that means you try to file a patent application for a technology which is 20 years old and this is already available in public domain, you will not get a patent, right? The next criteria is checked only when your invention has novelty. That means your invention is novel. So let us assume your invention is novel, but the second step is that if your invention is inventive step or not. Does it has inventive step or not? If the answer is no, you will not get a patent. Inventive step means what? It should have certain problems which are being solved by the solution that is proposed, and the solution what is proposed, it should be not obvious to a person skilled in the art, right? So any person who is working in the domain should, that invention should be non-obvious to him. If your invention has non-obviousness criteria, then you will get a patent granted for, and this criteria is also checked. Industrial application or industrial applicability means that your invention should have some industrial applicability. That means people should be capable of making it and using it. If something is hypothetical in nature, you will not get a patent granted for it. Okay. Section 3A, this is the section 3 is basically one of the most concrete criterias of Patent Act, which says that if your invention falls into any of these criterias, you will not get an invention granted for. Section 3A clearly indicates that anything that is frivolous or misleading inventions, you will not get a patent granted for. Best example of this is perpetual motion machine, right? Perpetual motion machine has very good advantages, applicabilities to it, but these are all contrasting to the nature. They are frivolous to nature, right? Means what? Second law of conservation of energy, it says that no, I think yeah, it's the second law of, the law of conservation of energy rather. Energy can neither be created nor destroyed. It can be converted from one source to another source. So what it means is that in order to have energy as output, there has to be energy as an input, and this energy as output always consumes the energy as an input. But in perpetual motion machine, we completely see this in contrast. Only one time you need to give the trigger, and the machine keeps on running again and again throughout the year or throughout the time. So this is something which is contradictory to the nature, contradictory to the law, natural law, established law. Such inventions are not patent eligible. Somebody say that without using any instrument, I can fly in air, without using parachute, without using aeroplane, without using any other things. This is again contrary to the natural law, because gravitational force does not allow you to fly in the air, right? So anything that is misleading or anything that is frivolous to human nature or nature, they are not considered as patent eligible. Section 3B of the Indian Patent Act says that inventions contrary to public order or mortality are not patent eligible, patentable. Examples: atomic bomb. Bombs are generally used to destruct something. That means they can kill people. Bullets. These are all examples of, contrary to public or mortality. Alcohol, right? Alcohol kills, obviously taken to a certain extent. Tobacco kills. These are all contrary to public order, and thus such inventions which are contrary are not patent eligible, right? Section 3H, basically method of agriculture or horticulture. Oh, sorry. Section 3C, mere discovery of scientific principle or abstract theory. For example, E is equal to MC square, and I came up with new invention referred to as A is equal to PQR. I'll not get a patent for it because it's a mere discovery of scientific principle or abstract theory, and E is equal to MC square is already known. I just replace E with something else, MC with something else. I'll not get a patent for it. Mere discovery of new form of known substance. For example, NaCl, the salt that we eat in our daily life, daily food items. If you come up with something different form and you just renamed it from salt to XYZ, you'll not get a patent for it because it's a discovery of a new form of known substance. You're not doing anything innovative in that. You're just copying it, the original content. Section 3E is substance obtained from mere admixture. A plus B is equal to C. This is well known. Okay. but it is a mere admixture. So for example, if I add salt in water, it will dissolve, right? This is known phenomenon, even though it is a not patented material, but it is a known phenomenon. I will not get a patent for it. So this is referred to as mere admixture. Section 3F, rearrangement and duplication of known devices. They are not patentable. For example, I am having an umbrella and I am having a torch. Now I was fed up of keeping two things separately. What I did is like I just fixed my battery to umbrella. I have just used two different devices and combined it into one, or let us say connected into one, but they all function differently. There is no connection of working of umbrella on the battery. Vice versa, battery's working does not depend on umbrella, and umbrella's working does not depend on battery. So such category of inventions wherein it has multiple devices but they have no connection to each other and they are just arrangement of each other, they will not get a patent for it. Method of agriculture or horticulture, how to breed or how to do an agriculture of the plants and vegetables. Such process or techniques are not patent eligible in India. Process of medicine treatment for human being, a process of performing an operation is not patentable, right? Performing an operation by a human being, how he performs, how many steps he takes, how much temperature he keeps in a room, the doctor, it is not patent eligible. Plants and animal as a whole are not patentable. Right? Tomorrow, if somebody comes and say, I have a beautiful plant and I want to patent it, you'll not get a patent. Why? Because there is a Breeders Act already there for it. There is a separate IPR for it. Similarly, you cannot claim on any animal, right? So hybrid animals that you see, for example, mule is a best example for it. A donkey and a horse, when breeded together, they actually produce a mule. So mule is something, an animal for which patent cannot be eligible subject matter. You cannot get a grant of a patent on that. Mathematical business method and computer program per se are not patentable. Any mathematical equation, mathematical formula, any business model or any business method, A is equal to B is equal to C, A plus B is equal to C, or how to run a pickle shop or how to run a newspaper shop, such inventions cannot be patentable. Similarly, computer programs, the coding that we write cannot be patented because they are already categorized under copyright criteria and under the literary work. Literary, dramatic, musical, or artistic work are not patentable. Why? Because they are already a part of a copyright, right? Scheme or rule of performing mental act. For example, an act of playing chess or act of playing Mario game cannot be patented because it is nothing invention. It is somebody's mental activities or his thoughts that have helped him to play the games, and thus Section 3M is not patentable according to it. Section 3N, method of presentation of information. For example, the way I am representing the PPT or the arrangement of the blocks on the PPT, what you are seeing currently, they cannot be patented because that is my creation. But this creation can be considered as artistic in nature, and hence, which IPR is eligible? Absolutely, copyright is eligible for artistic. Section 3O, topography of integrated circuit. The IC Layouts and Design Act helps you to do that, and thus it cannot be considered under the purview of Patents Act, right? Section 3P, traditional knowledge or aggregation of known properties. We saw at the start of this session that traditional knowledge is a database wherein all knowledge associated with the traditional ancestral information is stored in that, and thus such traditional knowledge are not patent eligible because they are already stored in the traditional knowledge database, right? And they may be in different language, but if the concept is same, they will still not be considered as patent eligible subject matter. Section 4 of the Patents Act refer to that, or any invention related to atomic energy, they are not considered patentable because they are already covered under the Atomic Energy Act. So this is a separate act like Patents Act which covers all the inventions related to atomic energy. Most importantly, it needs to be understood that this slide is very crucial because if your invention falls into any of these category or any of these criteria, you will not be eligible to get a patent granted. This is the most important part, and trust me, this is not what as an inventor one needs to think. This is a job of the examiner of a patent who is responsible for granting a patent to prove that your invention or the invention of that author or inventor is not patent eligible, right? But as an inventor, the job is only to ensure that your invention satisfies all these requirements. Most importantly, one thing one need to understand is that differentiating between which eligible IPR or which is the eligible IPR is really very crucial. As you may see that Patent Act clearly says that according to Section 3, L, Section 3M, Section 3N, Section 3O, these things are not patent eligible. That means they are eligible into some other different types of IPR, and thus the main focus in the last couple of time that I was just trying to convey is that differentiating and identify the differences between the IPR is really important. Which subject matter belongs to copyright, which subject matter belongs to trademark, which subject matter is not eligible for patent. It is really important to understand. And I really hope that using the real-time examples what I discussed in the last session as well as this session, it would have helped you to at least preliminary differentiate between which are the eligible subject matters for the invention. I hope you also recall the examples of Coca-Cola and other products that we discussed yesterday. So this is really important to understand which inventions are patent eligible, which inventions are not patent eligible. If they are not patent eligible, which appropriate type of IPR is it categorized into or can be categorized into. Only then you will be able to properly suggest or identify the IPR type and the IPR office, and then proceed further to get a grant of IPR and enjoy the benefits achieved out of it. Right? This is the most important part of the session today. So this is just a touch base. What we are going to do tomorrow is that we are going to discuss in detail about the patenting in terms of what happens in India, what happens in abroad, how to how do you file the patent application abroad, what are the various ways for it, what may be the costing for it, and all these things will be discussed in tomorrow's session. So tomorrow's session would be more one more step towards the patent filing and patent understanding. So I hope you appreciate we are going step by step towards the patent, and in this slide we have just touch based what are the inventions, what are patents, and what are the different criteria for getting a patent. And tomorrow's session would be crucial from the perspective of how a patent is important from Indian perspective, abroad, what are the steps involved, and the like things, right? So let's wrap today's session here, and I hope you enjoyed the session today. Please stay at home and take care of yourself and your loved ones. Thank you very much. Have a great day ahead.